I think the key with a guardianship is that the guardianship can be vacated. It's designated as a permanent plan, but it's not as permanent as adoption.
The child remains a dependent of the court.
Right. The court is still responsible for that child, and if a parent is still a parent, obviously, and if they want to bring it back before the court and try to get that modified, try to get more visitation, try to vacate that guardianship, then that's something that the court will have to consider. Whereas in an adoption, once there's a termination, or excuse me, in a termination, once the parent's rights are terminated, they're done.
Right. The guardianship, in other words, can be a form of permanency for the child that does not necessitate termination of parental rights. Right. And there are some cases where that would be
Maybe Barb can
reasonable.
elaborate on that.
And a lot of the cases involve adolescents where they don't want to be adopted. They're refusing to be adopted. They're older. Oftentimes they're multi-problems, high needs kids where a family is committed to providing for them, but they're not willing to do the step of adoption. Or there's a relationship with the biological parents that continuing that relationship under the format of a guardianship is appropriate. We have some kids that have severe disabilities that a guardianship may be more appropriate because of the intensive services that they can get. But it's typically with those populations, not as much with the younger kids.
Okay. So the last part of the timeline is termination. Let's talk briefly about that. Then we have some questions that foster parents have submitted that we'd like to get to before the end of this broadcast. Termination.
I think in terms of our case study here, let's assume that maybe we're a year down the line from when we first started, and Stacy has not done her alcohol and drug rehab program, and perhaps she is still living with Arthur here, who seems to be one of her bigger problems, and maybe she has not engaged in the service plan, and that would be the point where we would be at a permanency planning hearing, and the state would argue that the permanent plan should not be return home, and it should be termination of parental rights and adoption.
Please do tell me you love that look on her face. That is so fucking ugly. Okay. No, it would not actually, because first the child has to be abandoned. Duh. Can't you fucking read? This is the only section of fucking law that terminates a parent's rights, okay? So that means it says abandoned. Do you understand English? English, it says abandoned. That's all it says. It does not say abused or neglected right here. It does not. The only section of law that terminates a parent's rights defines an abandoned child. The only section of law that they can use to terminate a parent's rights only defines an abandoned child. It does not define an abused or neglected child, because abused or neglected children are defined under a completely different section of law. That means that no matter how bad the abuse is, they can't terminate unless the child is abandoned, which isn't hard to fucking do. Put them in jail. If they abuse their kid, it will be easy, right? Right. So fucking duh. Oh my God, this law has been the same for 55,000 years. That's why they have to do these videos, because they're fucking full of shit. They're playing people for their kids. It says abandoned right there. These bitches know that. She's a lawyer. She's a lawyer, she knows that.
And if the court orders that, I would be informing Stacy that she may be receiving a petition to terminate her parental rights, either by personal service or by a certified mailing. And that initiates a whole new court case. With another response date and another trial date, which from beginning to end, we may be looking at another 9 months until we come to a resolution, whether the child ends up going home. Sometimes a termination is a wake-up call for a parent that they need to really look at what they're doing. And sometimes they get it together and they get the child home prior to the termination trial, but that's not always the case.
And really, that's another reason why the Adoption and Safe Family Act was enacted by Congress, was that we have second and third generation folk now who grew up with the state, you know, kind of being in their family's business. And many of them become rather cavalier about that. Well, you know, we'll just kind of clean up the yard and they'll go away again. And I found when I was doing the CPS work that it was really, you really had to educate them that things had changed. That there were timelines now that, you know, you didn't have forever to get this fixed, and that you could terminate. And that was kind of a wake-up call for them.
Well, it is. There are some families that maybe came into the system in the early 90s when I started doing this, who the case could languish. And they had maybe 3 or 4 years to get their things together and to get these children to come home. If there's another child born into that same family with those same issues today in 2002, they're very surprised to hear that there are some very specific timelines, and there's just not that time to get these things done that they had before. Right.
And I personally think that it's a good thing that we have this timeline now, because, like you said, some of those kids are languishing in foster care for incredible amounts of time. Their sense of identity is gone, and who they belong to and what they're about is totally destroyed because they're in foster care for 3 or 4 years.
Well, one thing that I like to hear from the foster parents, as I say, but I also like either the foster parents or the CASAs or guardian ad litems to bring pictures of the kids. Because with a picture of the child there, it refocuses everyone in the hearing that this is what we're talking about. And the parents can talk all they like about, well, it's only been 15, 18 months and so forth. Well, the child's only 2 years old, which means that
The section of law defines an abandoned child. How was the child abandoned if they're 2 years old and you're terminating their rights? Then that means they were taken at birth. Okay, so how are they abandoned if they were just born? Because right here it says that 3 months is required to prove abandonment. Okay? So, yeah, nice try though.
majority of that child's life, the child has been in foster care. And that's not appropriate. We need to move forward.
And we do time life books for all of our kids. They have pictures from the day they arrived, how much they weighed, what, you know, everything about them, so that when they leave, hopefully they're going to go back to their parents and they'll be able to say, this is what you've missed, you know, and this is what I was about.
So very important.
And I think it's really important, too, to not sound so gloomy, you know. An awful lot of kids do go back home within 90 days of being, you know, in the service. Sometimes the parents just need a little extra help. Things have fallen on bad times, and the state jumps in there and shows them how to get their act back together, gives them services, and the kids are back home and everything's fine. So it's not all gloom and doom. Some of us foster parents, the type of kids that we take, it seems that way sometimes.
It's difficult work.
That if kids are going to go home, the likelihood statistically that they'll go home is going to happen in the first 90 days. And after that, it drops off significantly. You have a child in care for a year, the likelihood of return home is pretty minimal. So the quicker for everyone, the better.
This video was made in 2002. That means they've been terminating parents' rights illegally for the last 25 years. Okay? That's what that means. Because this section of law defines an abandoned child. It says that clear as day in the fucking law. That means they've been breaking the law for the last 20 years. These people that you see right here in front of you, and then the people after them, and the people after them, and the people after them. And all those parents who lost their kids should have never lost their kids because they did not abandon their child. This section only defines an abandoned child. These children were not abandoned. These people cannot regulate parental conduct because nowhere does it say that they can do this under this section of law. This is the Juvenile Court Act, not the Parent Court Act. They can't make parents do shit. They're breaking the law. Period. No, I'm not the first person to see this. All these people see it. They're just trying to convince you that it's not true because they want to take everybody's kids.
And I think that's why the concurrent planning is so important, is, while you're working to try to return the child home, there's a backup plan in case something happens, in case Stacy doesn't get into the services, in case she gets into the services and relapse. And so there's another plan there. So at 12 months, if a parent is not in compliance and not making progress, and it's our permanency planning hearing, the recommendation in all likelihood will be adoption as a permanent plan, but we continue to provide services to the parents in hopes that we can return the child home if that can happen.
The difficult, sorry, yeah. Go ahead this time.
You should sit next to each
Thank
other.
you, Sharon. Actually, no, you made me forget what I was going to say.
Well, the difficult cases, what I was going to say is the difficult cases are the cases where the parent is marginally engaged in services. They get into drug treatment, they do pretty well for a while, and then they fall out. We file a termination petition, and they're engaged in services to a sufficient degree. Maybe we have to continue the trial date to make sure, because we have a burden to meet on those cases. And if we can't meet the burden of what we're required to prove at a termination case, then we're unable to go forward. So,
Yeah, you have a burden to meet to follow the fucking law. Are you serious right now? You can't read the fucking law? It says abandoned. It doesn't say anything else. It says fucking abandoned. These people are fucking criminals, dude. This is the only section of law that terminates a parent's rights, and it says abandoned. It does not say abuse or neglect or parents have to do services or any of that. As a matter of fact, it doesn't even separate bio parents and foster parents, because the parent is not supposed to be there unless they agree to the order and agree to abandon their child. They can't be there. See, a long time ago, parents, well, still today, that parents used to agree to dependencies so that the state could pay for their juvenile to go to drug treatment. That's why a parent would agree. They're making parents agree to do services to better themselves. That's not what it's for. It's for juvenile rehabilitation. There's no such law under this section that says a parent has to do anything. Nothing. Like absolutely fucking nothing. If the law doesn't say you have to do it, then you don't have to do it. They can kiss your ass and bye-bye. Those are not your kids, you fucking kidnapper.
those are the cases I think that are difficult, that take a long time, and those are probably the kind of cases that are extremely frustrating for foster parents that are hoping to have some permanence for the child.
And I think a lot of times when that is the case, and I've seen that actual case happen more than once, the child does go back home because the parents have met just enough of their responsibilities, and then down the road you may visit juvenile hall and find their kid in juvenile hall because he's been acting up, getting in trouble, lack of supervision, and you tell yourself all along, you know, this should not have happened, but it had to happen that way because we have to follow the rules.
Right.
Well, and I think the key is we cannot create perfect parents, and we need to create safe families for kids to go to. And if that can happen to their birth parent, then that's where kids should be. But they're not going to be perfect.
You know, one of the things that I think has really strengthened the whole process is in the last 5 years, foster parents have become a larger part of the team with a greater amount of respect, and I think that's fostered using that word, a greater relationship, better working relationship with caseworkers especially, and the courts, a better understanding. The education process has really made it a lot better too. But I don't think things have ever been better for a foster parent, foster kids, or the department as a whole than it has been in this last 5 years.
That's very true. There are 5 competencies now in our pre-service curriculum, and they're to keep kids safe, to be on top of their developmental needs, to be part of a professional child welfare team is right up there as well. And that's where the education comes in. That's why we're here tonight, to encourage foster parents to be part of this dependency process. We really should talk about diversity a little bit. What, as a court system, do we do here to ensure that people with English as a second language, or who might have developmental disability issues, cultural differences, how do we address those? How does the bench educate itself in terms of that, Commissioner?
Well, education-wise, the Superior Court Association for our state has conferences twice a year, which generally has some aspects addressed to dependencies and some diversity considerations and cultural considerations. And then the Department of Social and Health Services runs the Children's Justice Conference now for about 8 years now going, I think, and that's an extraordinary 3 days in Seattle where they bring together a compilation of experts from around the country, which are nationally known speakers, to talk on a variety of topics, and that's very helpful. And then locally, we do the best we can. We've had some judges from the Indian tribes that have come in and explained to us ICWAC and some other considerations that provide insight that we otherwise would be lacking, because particularly with the Indian culture in our community and the number of different tribes that are around, it becomes a problem sometimes because we don't have that great an expertise in the area, so we have to find it where we can.
True. And we didn't talk a lot about ICW, in the Indian Child Welfare Act, but it really does dictate where children are placed or who has jurisdiction. We didn't talk about the Multi-Ethnic Placement Act, which says that we are not to use race, other than with regard to Native children, we are not to use race as a sole predictor or sole selector of a placement. And that was a question that foster parents had brought in or phoned in, was can only African American or Latino foster parents care for children of those particular cultures? The answer is no. There's no restriction. In fact, we may not use that as a sole indicator of placement. There was another question here about what is a federally recognized tribe?
Well, I did some research on that for you, and there's not really an answer, but there's a list. The Bureau of Indian Affairs generates a federal list, and if the tribe is listed on the list, they are a federally recognized Indian tribe. If they're not, they're not. And the decision of what's on the list and what's not, quite frankly, is political.
Okay, well, that's a good answer.
And I think the commissioner has done a really good job on asking parents at the shelter care hearings if there is Native American ancestry, because the department is obligated to research that and identify Native kids and ensure that their needs are met, whether it's placement in an identified Native home, and involve the identified tribes and the local Indian Child Welfare Council on that.
And that's an issue that really slows down how quickly these cases can move around.
And actually, the department does exhaustive work whenever there's a question of a child's background. Foster parents have known and watched the process proceed. It takes a long time because you are so thorough in making sure that these kids are placed properly.
Well, the Indian culture, from my experience, is there's a significant break for permanency in terms of what a child should have when the child cannot go back to their parents. The Anglo-Saxon approach is let's go forward with termination, adoption, guardianship, what have you, depending upon other factors. The Indian culture says no. The Indian culture says this child is a child of the tribe. And whether or not the biological parents can have the children back doesn't eliminate the biological aunts and uncles, but more importantly, the emotional aunts and uncles of the tribe, which have raised the other children of the tribe, including this child, or could. And so we'll frequently come up close to a termination trial, and the tribe will step in and say, excuse us, but the child is now coming with us, and under the law in certain circumstances, that can happen. They have a trump card there, effectively, and that's not wrong or right, it's just, it is. And we have to be sensitive to those things.
One more factor about that kind of situation is that sometimes the parents agree that the tribe should step in and take some responsibility towards this child. But what slows down the process even more than that is when the parents disagree that the tribe should step in and take the child. That generates several more court hearings, sometimes more than several, as we've had in the past. And I think one case in particular, maybe an extra year or so, deciding that issue. But that's indeed is a huge factor as to how long that process will take.
And just one more comment on ICWAC, and then we'll move to something else. But The law is very clear. The decision on whether or not a child is a member of the tribe is not my decision. It's not the state of Washington's decision. It is the decision of the tribe, exclusively and binding upon everybody else.
And that varies from tribe to tribe,
Sure it does.
whether it's maternal or paternal line, percentages and so forth. So check with your local tribe, I guess, is really what you have to do there.
But you're not just dealing with your local
Right.
tribe.
No, that's
we
true.
oftentimes are dealing with tribes in many other states, which then gets the interstate compact also involved.
No, that's true.
And
That
the
also-
Alaskan tribes as well.
Anne, as assigned counsel, here's a question that I would be interested in having you consider. How can we plan for permanency for children when biological parents may temporarily clean up a drug problem, but then and get their children back and then relapse? With multiple relapses, how do we provide permanency for these kids while still protecting parental rights?
Well, as a defense attorney, my primary responsibility here is to advocate on behalf of the parents. And these parents have a right to have that time to, as you said, clean up their act and to do these services and show progress. I think society has recognized over the past few years that especially drug abuse is a rather insidious disease at times, and relapse is actually a part of that. So one relapse, two relapse, it really is unclear as to when is enough enough?
When is it a lost cause?
When is it a lost cause? Because I will keep fighting for that person to have another chance, because you never know if that's the opportunity that they take to lead a clean and sober lifestyle.
But I think that's the very issue where the Adoption and Safe Families Act conflicts with the parents and their need for services, because the time frames with ASFA are so much shorter than what many parents need in order to clean up.
Well, and the resources available for drug treatment beyond 28 days, I mean, you know, that's just scratching the surface, and keeping mothers and babies together and treatment. And
A lot of folks wonder why trials get continued. And, you know, those defense lawyers keep asking for those trials to be
Commissioner Rupp,
continued.
I'm asking that question now.
We asked that this morning.
Yes, he did.
Do you always believe that you're doing the right thing when you're defending some of these
You know,
people?
that does not enter into it.
Doesn't matter.
I have a job to do, and these people need legal assistance in getting their position put out there before the court.
So you can't be emotional about it.
Sleep at night.
No, no. You know, and depending on, you know, my position is going to be very different on whether I'm representing Stacy here or Steve.
Clearly different.
Very clearly different, and you have to be able to represent the interests of these two people and get that out there before the court without getting personally involved, because I think that does color some of your legal
You know,
representation.
on a professional basis, the lawyers representing parents have the easiest job because they clearly know what they're supposed to do. The lawyers representing kids have a difficult job because they're torn between what's the kid saying and what's best interest in the guardian ad litem. Foster parents have a hellacious job because they're expected to do everything and do it right and then lose it. And the state and the department has a horrendous job because they're supposed to be balancing these things, which is my job also, balance between the needs for security and safety for the child and the need to give the parent services to the parents to get them clean and sober, whatever the problem is, and when is enough enough. And it's an interesting process.
And you get to make that call sometimes.
Sometimes, which is why I have coal black hair.
And as a social worker, and as, you know, listening to social workers, having to go into the court and recommend that these parents should not have any rights to their children any longer is very difficult. It's not a decision that social workers take very lightly, and sometimes you have to push them through various staffings within the department to make that decision. This is a parent that they have developed a relationship with over a year, sometimes 2 years. And it doesn't mean that they don't love their child. It just means that they should not have the parenting of that child.
To get back to your question a little bit, I think there's something very interesting that was brought to all of our attention at a meeting from an alcohol and drug treatment provider who said some of these people who are involved with substance abuse, imagine yourself if you've ever endured a surgery or a medical procedure and you've had those painkillers. Imagine that foggy feeling that you have, and that's what these folks deal with every day.
Not being able to process the information.
No. If you have a list, you get your ISSP and you have a list of 8 things you have to go do.
Right.
And you've got telephone numbers and places to go. You may not have a driver's license. You may not have a permanent place to live, so you don't know how to get here. And if you have that foggy feeling,
haze, right.
that haze, this becomes really, really difficult.
And underlying depression as well. The good side of what we do is exemplified in something that will take place in this county or in this region tomorrow, and that is a graduation ceremony for 52 young men and women who are aging out of care with their high school diplomas, thanks in no small part to our foster parents. And so tomorrow, you will be the keynote speaker at this thing. And we have a question here that I think it would be a nice way to end our evening together. What can the court do to encourage adolescent foster children who have given up on becoming successful and independent? What does the court do or can do to give kids hope that they can move beyond and achieve in spite of all that's happened?
Come listen to my talk tomorrow. When kids come to court, I try desperately to connect with them in some manner. Because, as I say, they're there in an isolated frame of time. They don't understand what's going on, and here's this gray-haired man in a robe up there, and everybody's being deferential. What's this all about? So I try to connect with them, and I try to find something they're interested in. We'll talk sports, or we'll talk some interests, or we'll talk school. I want to see their report cards. I'll give them encouragement where I can. I'll kick them in the butt where I can. But the idea is to try to, I think, to get a little personal with them, to give them some immediate goal that is achievable, and then build on that. And the foster parents are very helpful on doing those types of things on a regular basis. When the kids come in and see me, usually it's because they're in trouble. And sometimes we're successful, and sometimes they keep coming back.
And so foster parents, in a letter to the court, can say, I have concerns that Johnny is doing X, Y, and Z that's not in his best interest. Would you mind having a little chat with him?
Not a problem.
The commissioner told one of my kids, he has a motorbike, that, yeah, you can bring it to your foster parent's house, but you can't ride it till you get a B average.
There you go.
He hasn't got his B average yet. He hasn't ridden his motorbike either, but at least the commissioner was trying. That's the best we can do.
So I think to sum all of this up, it does take a village. This is all part of the village. And in many ways, we're all parenting these children together. And maybe if we all work hard enough and work toward the same goal, we can be successful in parenting these kids.
We are all working very hard.
And together.
Every day, you betcha.
Right. We want to thank you for joining us this evening. It's been a real pleasure to be in the midst of these folks who spend so much time and energy and have so much talent and work for the benefit of the children of this community. If you have comments, feel free to email us at the email address at the bottom of the web page. We are happy to hear from you and want to know what kinds of subjects you want to have addressed in the future. In weeks to come, there will be webcasts on attachment issues and de-escalation techniques to be used with children who are extremely angry. Thank you again for opening your hearts and homes to these children, because we couldn't do what we do without you. And I want to say thank you on behalf of our panel to South Kitsap High School for